We're talking about the subject of wills. Nearly 2/3 of Britons do not have a valid will, according to research by financial advice service unbiased.co.uk, even though this risks inflicting great emotional and financial pain to their loved ones.
That's
yes.
right, yeah.
What happens if we don't make a will?
Well, all hell can break loose, actually.
Lord.
Generally speaking, you need to make a will because you need to face your mortality in the first instance, and that's something people find a bit difficult to do. And you've got to face up to you think should inherit your property, assuming you have much to leave. But even then, if you haven't got much, there might be issues about children or about specific requests or items that you've got. In terms of how you go about it, start by making a list of all your assets.
Can I just interrupt you for a moment? What about this possibility of going to WH Smith's or some other retailer, buying one of the will forms which are sold for that purpose, and completing that and stick it in a drawer? Is that a possible way of going about it?
Well, it's certainly possible because WH Smith sells them.
Yes,
but
is it going to cause problems?
I think it's inherently risky for two reasons, really. One is that it's something that you need advice on, because you've got to think of things like what happens if so-and-so dies first instead of the order that I think they're going to die in. You've got to think about tax. I mean, okay, if you've got an estate that's worth, £5,000, maybe go to WH Smith's, although even then you could find it ends up in the wrong place if you don't do it in the right way. And the other reason is the formalities, although it's probably the second reason in terms of likelihood of it going wrong, I suppose, because if people do it properly and they follow the rules, they'll get it witnessed properly. But it's amazing how many people don't, and so you end up with a number of times we see these homemade wills. And I mean, at the end of the day, we are insured, so we don't want things to go wrong. But life being what it is, very occasionally, even professionals get it wrong. And if they do, they're fully insured.
So in normal circumstances, what do we have to do? What should we? What's the process we should go through?
Well, start by making a list of your assets. Secondly, list all those people that you want to inherit, and then you have to think about perhaps why you're excluding some people. I mean, it takes a lot to do that, and maybe a reason, maybe because they've won a lottery and they're going to have their own funds which way out of proportion to the others. Although even then, you've got to think of the emotional effect of it. Perhaps you can make a clause saying, I leave it equally on condition that they leave some of their lottery money to... I don't know whether that would work legally, actually, but anyway. If you're a parent, decide what you want, who you want as a guardian for your children, and at what age you want your children to inherit, because it might be 18, it might be 21, it might be even later. Decide who you want to administer your estate, someone you can trust to deal with your assets. This is an important point. It may not be someone who actually is the beneficiary, although typically it usually is. But they've got to agree to do it, and there's a certain amount of onerous responsibility there, especially in a contentious situation, or one that's likely to be contentious, and I've certainly seen executives want to get out.
So is the best thing, if you've got a sort of a business, a property, to actually discuss maybe with the people you're going to share your...
Well, that's what the programme certainly says.
Beforehand, just to get some... Are you happy with this if I do this in general?
Yeah. And give your reasons, and might be prepared to amend it if there's reasons, because we all should be open to persuasion in certain circumstances. Go to see a solicitor to prepare the will. Although you can draft your will yourself, and blank will forms for completion are available on the internet or from high street stationers. There are many pitfalls in preparing a will and making sure it is valid and unambiguous. Unambiguous is quite important, because if the wording isn't clear, and of course we all know that legal wording can be a little difficult sometimes to interpret, but even sometimes this simple use of language can be misinterpreted.
How much would it, in a ballpark figure, say for a simple homeowner, would it be £200 to £700? Is that the sort of thing?
That's probably a range that's reasonable. I mean, a very basic will, if it was a very simple estate, which might include a house but not much more, for a single person might be a couple of £100, so it's not a lot, relatively speaking. Mirror wills, which is husband and wife, you might be sort of not quite double that, a bit less than double, because you get a bit of a discount for doing 2. But that's the very basic will. A lot of people do need more than that, and time will be more. But I would have thought it was unusual for wills to push up over the late hundreds. I mean, it's not that expensive, and if people want to do this and should do it, it would be something perhaps that they could set aside a bit of money for. I mean, and maybe do perhaps in 6 months' time.
Yes.
Because you never know when you're going to unfortunately disappear. But it's something that shouldn't be put off. What happens so many times, actually, people doing it in hospital, unfortunately, in the last stages of their life. And
I guess there might then be a challenge to the will, which is another thing.
Yes.
Maybe I don't know how much time we got left to talk about that. A challenge to the will if the will was made by a very, very infirm person close to the end of their life.
Yes, there could well be. So you're also creating that risk. Even very briefly, intestacy is what you're trying to avoid here, and there's obviously a complex subject. But to give you a feel for that, the intestacy rules stipulate a surviving husband or wife only receives the first 250,000 of the deceased spouse's estate outright, if there are children of the marriage. The rest is split 50-50, with 50% passing outright to the children of the marriage, and the remaining 50 held on trust, with the spouse getting the income during lifetime. I mean, a lot of houses these days are worth more than 250,000.
So without a will, you can't assume anything. A wife can't assume that it'll all go to her.
No.
All kinds of things could happen. Some of it may go to the government, an unfairly large proportion maybe. So the basic message is the worst thing to do is to do nothing.